Alex here with part 203 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. I actually meant to say Alex and Brittany here. This is another one of the videos that is going to the adoption petition. So if I remember correctly, this one has to do with trying to get the court to waive the home inspection by CPS. What did you think about the prospect of CPS, or I guess they also call it DFS in Nevada, doing a home inspection on us?
Well, I honestly didn't care at all. The only thing they were gonna, in my opinion, notice is that we had a lot of animals, because we had, 4 then? So I didn't have a problem with it.
Yeah, I don't even think I talked to you about it because I was pretty confident that I would get a waiver, and I did get a waiver. And that is because of my blood connection to my son. So the home inspection is in the statutes. It specifically states that the home inspection must occur before the adoption can proceed. However, there is another statute that follows that specifically mentions a list of exceptions. And in that list of exceptions, they will allow the court to waive the home inspection if you are within, if one of the parties to the adoption is within the 3rd degree of consanguinity, which is blood relation. So I suppose, oh, you know what? I'll mention one more thing. I remember an attorney telling me that, you know, you might have to do the home inspection anyway. And I thought that was a little weird because there was a statute that said otherwise, but I read it more carefully, and it just gives the court the discretion to waive the home inspection. And I think the insinuation was that if you do your adoption with an attorney, it'll get waived. And if you try to represent yourself, the court will exercise its discretion to not use that statute and force you to go through the home inspection anyway. I can understand why the attorney told me that now, in hindsight, having seen how the courts exercise their discretion. But luckily, in my particular case, even though I was representing myself, District Court Judge Jennifer Elliott did allow, she did grant my motion to waive. And we'll go over that later when we actually get to that point in the My Docket series. But let's take a look at what I have filed. Here we have the motion for waiver of welfare investigation. Standard introductory paragraph indicates both Brittany and I are filing the motion for waiver of welfare investigation, and that we are appearing in proper person, which means well, actually it doesn't say that, and it should say that. So that's not good that it doesn't say that, but of course no attorney's name is mentioned, so the court can tell. In any event, we are appearing without counsel, appearing in proper person. Motion is based upon the following. So the summary is that the motion urges the court to waive the investigation and report generally required by the agency which provides child welfare services. Factual background: I am the natural father of the child and am within 1 degree of consanguinity. My wife is my spouse and the stepmother of the child. The child is the common minor child of both myself and my ex. I have instituted proceedings to terminate my ex's parental rights. I have primary physical custody, I have sole legal custody, and the child has lived with both myself and Brittany since November 4th, 2014. The legal analysis is relatively simple. In the statute I'm citing is 127.120 sub 2, which states that if one of us is within the 3rd degree of consanguinity, the court has the discretion to waive the investigation. I like this part a lot, actually. This is a good one for Brittany to talk about. I'm going to go ahead and read. So here I am citing the thorough vetting, those are my words, of my wife by the 2nd Judicial District Court, specifically District Court Judge Bridget Robb, and what she had to say about my wife, and I'm going to read it verbatim. The court recognized that Mr. Falcone's spouse, Brittany Falcone, demonstrated remarkable maturity in recognizing and understanding her role as a step-parent, an insight that the court acknowledged rarely seen from a step-parent. Mrs. Falcone is a step parent who absolutely understands her role, yet is still willing to step up and be a source of comfort and support to the minor child. Mrs. Falcone is a person that Mrs. Farrar should want on her side, not someone that she should be trying to alienate. What did you think about those words from the judge about you?
I was really surprised.
Yeah,
I I was surprised. I think I even got emotional.
you did.
It was just nice. It was validation.
Yeah,
I never came into the situation to take over. It just,
yeah.
you know, things changed.
What I was going to say earlier is I wish you could have been there and seen her say that about you. That would have been nice. You, of course, had to go pick them up, but it was good for you to see
Yeah.
the Jabs video, and it was good for you to read her words on paper. Let's
Yeah.
continue on. So the conclusion is simple. Please waive the investigation. And you can see both my wife and I signed the motion. And the verification indicates under penalty of perjury that the facts alleged are true and correct. Both myself and my wife signed it. And the list of exhibits. We got 2 orders, guys, but as is standard with the My Docket series, I don't go over stuff we've already gone over. If you've been watching the My Docket series in order, then you will already have had my analysis on both of these orders. And of course, you can always go down in the description below, click on the link, download for yourself, take a look, and if you think that there's something that I should have covered, mention it down in the comments below. Last document is a request for submission for motion without oral argument. District 8 does not use requests for submissions. I think that's weird that I filed this. Please take a look at my video on the topic request for submission. There is a chance that EDCR 5.11 sub B required it. I doubt it. It was probably just me thinking, hey, this is what I do in District 2, so I probably had to do it in District 8 too, which is, I found out later on to be not the case. And Exhibit 1 here, and this is a proposed order. This is not a signed order, guys, so I'm not going to go over this right now. My wife and I did prepare an order for the judge. The judge does sign the proposed order that we prepared. If you want to learn more about proposed orders, watch my video on the topic, proposed orders. When we get to the point in the My Docket series where this order is signed, then we will go through the order in detail. Going into the aftermath, it looks like we filed 2 documents. They were free filings, so we incurred $0 in costs, and we didn't have an attorney, so we incurred $0 in attorney fees. As with our previous videos, feel free to post them down in the comments below, and I will see you guys next time.